first panel today is effective and ethical governance. That "and" is really important. You can't be effective unless you are ethical, especially as a trustee in a region when you're looking at long-term goals and strategies for your institution. Really, just a synopsis of all of this is just how to do the right thing in the right way. Out of curiosity, how many of you are trustees at a community college?
All right.
Thank you for your service. How about appointed regents? Got a couple, great, awesome.
Good too.
Thank you, thank you. So we have a broad array of talent and experience up here with me. I am Doug Brock. I am general counsel at the Texas Higher Education Coordinating Board. And next to me is Nelly Rivera. I'll let her introduce herself.
Hello, everyone, and congratulations on your new roles. It is such an important role. It comes with a lot of responsibilities. Thank you very much for taking this on. My name is Nelly Herrera. I'm the general counsel with the Texas State University System. Very happy and honored to be with you today.
Augie?
My name is Agustin Rivera. Most of you in the room actually know me, and you know me as Augie. I have the honor of serving as the general counsel for Del Mar Community College down in Corpus Christi. I've served on panels like this before, and I find it really, I want to join Nelly and Doug in congratulating you and also thanking you for stepping up. For those of you community college friends in the audience, to me, there's no greater honor than serving your community locally. Being elected and having the trust of the community and having you come in and serve as a trustee or a regent at your community college. But now buckle up and get ready, because now the fun's just about to start, but so is the work. Happy to be here with you.
And as Sarah said at the outset, this is required training for new trustees and regents. So there are items that we have to go over in this session, but we are going to attempt to try to keep it conversational and leave time at the end for any questions you may have. So to kick it off, Nelly, why is it important for a new regent to understand the difference between individual trustee authority and the authority of the board as a whole?
That's a great question. And it's a really important question. Let's just jump right into it. You, as an individual regent, don't really have authority to act by yourself. You act as a part of a body. Thank you. You act as part of a body, a larger body, a collective body. You are one member of a collective body that acts, and the body acts through its formal votes. So keep in mind, while you have been either appointed or elected to your position, you do not have the authority to act alone. No regent or trustee acts alone. You only act through your capacity as part of this broader body. And you want to keep that in mind, because what will happen here is recognizing your role as part of this other larger body will help you to do two things. It will help you to ensure that you do not inadvertently expose your institution to any kind of legal harm, right? It will also do something else equally important. It will help you to prevent from engaging in activities that could be considered outside of your authority. Some people would refer to it, and I refer to it, as somebody who is acting in an ultra-virus capacity. In other words, you're acting outside the scope of your authority as a regent that serves as part of this collective body. You do not want to find yourself engaging in ultra-virus activities, because two things will happen here. You will expose your institution to legal harm, potentially, and potentially, equally important, you may be exposing yourself to personal liability, and you want to avoid that.
Follow-up question on that, Nelly. You mentioned that acting ultra-vires can result in personal liability. Would an institution's D&O insurance policy cover that?
Yeah, let's talk about that for a minute, right? So let's talk about ultra-virus risk, okay? An ultra-virus risk basically refers to the danger that a governmental body, this board, I should say, it refers to the danger that the board will take action outside of the authority that it has been granted. So let's stop for a minute and look at this. How does this board get its authority to act? I'll tell you how. State statute, that's one of the sources. The institution's policies, another source. And the board's bylaws, if you have bylaws. Those items, those sources give the authority to this board to act. If the board is engaging in activity that is outside of its authority, then it will be subjecting itself to actual potential harm to the institution, not just legal harm, reputational harm. And it would also be subjecting yourselves to legal liability. Now, Doug asked me, well, what about these DNO policies? DNO policies are director and officers policies. Most of your institutions will have such policies. But do not think, it's okay, no problem here. If I do something that is outside the scope of my authority, I'm sure the DNO policy will cover. No, I am here to tell you that is probably not going to be the case, because most DNO policies have an exception in there, and the exception is they will not cover any claim that is alleged to have been engaged, where a region has been alleged to have been engaged in ultra-virus activities, activities that are beyond the scope of their authority. So DNO policies will not be what you can rely on if you are acting outside the scope of your authority. Does that make sense? Any
Doug,
questions? I'm sorry, go ahead.
Yeah, of course.
So yeah, I was going to have a question for the audience. So Nellie mentioned bylaws that you all have. And so if you're a new trustee, I'm not going to ask you or call you out whether you've read your bylaws yet, but you should have it top of list.
So here's something else. Now, why does all of this matter? Well, I'll tell you why. Because as a regent or a trustee, you have certain duties and responsibilities, right? You have the duty of loyalty, the duty of care, the duty of obedience. And for this, I'm going to call on my friend Augie. Augie, can you speak to us about this duty of loyalty?
Sure. So duties of loyalty aren't going to be something that you find in state statute. You may find them in your board bylaws, but they're the underpinning, the foundation for everything that you do. They're considered best practices, but they also translate into legal obligations. So when we talk about a duty of loyalty or a duty of care or duty of obedience, that means that that translates into specific do's and don'ts and specific rules of conduct for you that you must comply with. With respect to the specific duty of loyalty, it requires you to ensure that the activities and the programming of the college are advancing your institution's goals. There also, a duty of loyalty requires you to have systems in place to recognize when conflicts of interest come up. Because again, the duty of loyalty is simply that. You must have absolute supreme loyalty to your institution and not do anything that runs contrary to its mission or vision. And then every decision you make, and I'm not joking, every decision that you make must be in the best interests of the institution. Now, does that mean that your regent, that your boards of regents or trustees are always going to be 9-0 or 7-0 or 5-0, however your constitution? No, it's not going to mean that. You may actually have a legitimate disagreement over what is in the best interest of your institution. What's important is that you as an individual regent, each and every time you're making a decision for your institution, that you're following that duty of loyalty and making sure that you're in fact making a decision that's in the best interest of the college or university. With regard to the duty of obedience, Doug, you want to tell us about that?
Thank you, Augie. Happy to. So, duty of obedience could be simply stated as, well, you need to be obedient to the laws and regulations of the state, as well as the bylaws and your board operating procedures. It sounds simple, right? But I would say that in order to be obedient, you first have to know the statutes that pertain to your institution, the regulations that pertain to your institution, your bylaws and board operating procedures. So you need to take the time to go to trainings like this to become educated on what are the different duties that our board is responsible for and what are the limitations there. What are the regulations that are promulgated by the coordinating board or by other state agencies? And then what's in your board operating procedures and bylaws? Also be cognizant of that, look at when was the last time those bylaws were reviewed and updated by the board? Because as you're aware, the legislature meets every 2 years. And if you're not regularly updating those may be in conflict with law or state regulations. So you can always bring that back to the board of like, hey, I think it's time, especially when new board members come on, it's a good opportunity to relook at your board operatings and bylaws and make sure everybody is aware of everything in there, that it's working for your board, and it helps you meet these other duties we're talking about. So, ignorance is not a defense. Nellie was talking about ultra vires actions. It could be like, well, I didn't know state law prohibited us from doing, X. That's not going to get you anywhere in court. Ignorance is not an excuse, so you need to take the time on the front end to become educated. Work within your bylaws, but work through your general counsel. If you need counsel, make sure that your bylaws allow you to directly go to the general counsel. If not, get approval. Sit down, have those conversations on the front end. I can speak as general counsel. I am always much more happy and willing when somebody comes to me on, hey, we're thinking about doing X, instead of we did X and now we need help. I mean, that happens, but the more inquisitive, the more time you spend on the front end learning, the better off you will be, and the better you will be able to meet this duty of obedience to the board. So the final duty is the duty of care. Nellie, will you take some time and explain what the duty of care means for a regent or trustee?
Oh, absolutely. So the duty of care is actually a fun duty, I think. And the reason it's fun is because it actually is why you're here, right? The duty of care will help you in your role as a trustee or regent, because the duty of the care requires that you be informed, that you be aware of what is going to be presented to you as you participate in your board proceedings. And so what this is required, this element here requires that you be aware of the things that are going to be presented to you and that you become familiar with what's presented to you. Now, this does not require that you be subject matter experts on everything, because you're going to see an array of matters, an array of issues, contracts, issues with all kinds of taxes, just anything. No one expects you to be subject matter experts in these individual fields. That's not the standard. The standard is that you be informed and that you rely on those individuals who actually are subject matter experts. For example, you all will have access to your general counsel. You all will have access to your CFOs, to your auditors. You rely on those individuals who are supposed to be subject matter experts in those fields when you have questions. So this is how you exercise your duty of care. You become aware, you become familiar with what's coming in. You rely on those people who are experts to help you, provide you with information so that you can make the best decision possible. Now, here are some real simple things to do in order to make sure that you engage in this duty of care. Be sure you attend your meetings regularly. Be sure you review the materials that are provided to you prior to your meeting. You should always have those board books. You should always be able to go through them, make your questions, so that at your board meeting, you can engage in discussions. You can ask those well-informed questions of those subject matter experts, and then you can make these decisions. Because when you're exercising your duty of care, you're basically doing what any reasonable regent or trustee is doing in exercising and making these decisions. So those are those three elements: the duty of loyalty, the duty of obedience, the duty of care. And these are the things that are going to be so important to you all. So we've talked about those three things.
Let me add one thing, just to put it into context.
Yes,
I mean,
of course.
Nellie and Doug touched upon how you keep up with these duties. Well, you're not, if you're brand new, you're not going to understand it until you are actually in it. But in addition to the resources that they talked about, you have the opportunity to come to conferences like this. There's also some at the state level, and many of you are familiar with what ACCT, for example, does at the national level. I encourage you to get involved, to get engaged, and I'm proud to say that Texas is actually quite engaged and involved at the national level in helping with the community college discussion that's taking on there. And I see folks here that I know that are very much engaged in that. But do that. Go and interact with others that are doing the same thing you are, and go check out sessions. Like Nellie said, none of you are going to be expected to be subject matter experts. And in fact, that can get you into trouble. If you come on the board and you're a CPA and you want to start doing the audit yourself of your institution. I'm not saying that's ever happened, but maybe hypothetically I heard that it has happened. Or lawyers, forget about it. I mean, I serve on other boards, but having a lawyer on the board can be a mixed blessing. Sometimes, because as a lawyer on the board, the lawyer's not acting as a lawyer for the board. Should never do that. The lawyer board member should be acting as a board member, relying on others. But I wanted to point out how important it is to keep yourself involved and updated. And again, I'll follow up with this. Go check out your bylaws. About 10 years ago, I went to an ACCT conference nationally, and I had a panel on board ethics and governance. I think Chancellor Hellyer was one of my panels one time in New Orleans, but I put that panel on for a few years. And so it was a room like this with lots of community college trustees. And I remember I said, I don't want to embarrass anybody, but how many of you read your code of ethics in your bylaws? And believe it or not, not everybody raised their hands. And frankly, they were there because they wanted to know more about it. And so what we do at Del Mar College, I want to give you a best practice. Once a year, our regents have me guide them through the bylaws and the ethical principles at Del Mar. We sit there and we go through it again. And then I'll give them an update on something that's happened recently, some Supreme Court case or some new legislation. And at the end of the training session, which happens in an open board meeting in March, they sit down and they sign a statement that says that they commit to subscribing to the highest ethical principles in accordance with the bylaws. Now, for the rest of the year, they do this publicly in front of everybody else, and I have a takeaway that I'm going to give you at the end, but that's worked out really well for us. It serves as a reminder at least once a year, if we don't have something that comes up, and that these bylaws, these ethical principles that you all subscribe to, like the duty of loyalty, of care, and obedience, actually mean something and aren't just words. Thank you. Yeah.
Well, I have to tell you too, transitioning now from this topic, the three duties that we talked about, you've already touched on this, Augie, and that is what happens when you as a board member, you have a conflict. There's a conflict of interest. Could you speak to that?
Sure. So conflicts of interest are really important, and as a public board member, you have to be careful. There are going to be conflicts of interest that arise because a vendor or a contractor that you happen to do business with, or that you have an ownership interest in, may be interested in applying for or competing for a contract. You've got to be careful with those and really look at your business portfolio. Because you may be in a community where you're actually quite successful. I mean, this happens. I mean, we've got 50 community colleges in Texas, and they're all different and come from different communities. And so conflicts of interest are something to pay very close attention to. There are technical requirements. Chapter 171 of the Texas Local Government Code applies to community college trustees. It covers disclosures that you have to make. It gives you the different percentages of ownership in a company, for example, that would require you to disclose something, to abstain or to keep from voting on the award of a contract in which an interested company is participating in, and then you'd have to back away and not participate at all in the conversation. And there are disclosure requirements that you have to file, abstention. Statements that say I'm abstaining because I'm not going to get involved or do this. So Chapter 171, Chapter 176 of the Local Government Code also talks about it, puts a requirement on vendors as well. And I believe that there's something also for university systems. University systems, I'm not as informed about because we just have a different, we're a little more regulated at the local government stage, which includes community colleges. But I know that university systems as well have very detailed conflict of interest requirements that require you to disclose when you've got something that potentially conflicts with, like I say, a vendor or a business that's going to be competing for business. So
That's correct.
pay attention to your rules and speak to your lawyer. Nellie mentioned general counsels. I know this from our community college group. Not everybody has a general counsel in-house, but you have lawyers, so don't ever hesitate to ask. That's the important thing.
Did you have a question?
I have a question,
yes.
going back to what you said about the bylaws. So do you recommend or suggest that once you have reviewed the bylaws and the governance policy, have your general counsel to look over it, make sure that we're in compliance with state laws before the board approves the bylaws and the policy governance?
Yes.
Okay. I just wanna make
Absolutely.
sure. The process
No, that's
in
a
updating your bylaws.
great question, trustee, because that's not something that you should just, again, using Del Mar as an example.
Yes.
I represented Del Mar College. I was in private practice and started representing them as outside counsel for 10 years. And then 10 years ago, I went in-house and became the general counsel. So that's 20 years of representation of Del Mar College. And in that time, they have actually, two or three times, they have the board's appointed an ad hoc committee that went back and looked at revising and updating. And the last time we did it, I think, was a few years ago. And it led to changes in the policies. So, and it was, the lawyer was very much at the table on that. So,
That should be reviewed, you said, every couple of years, am I correct?
as frequently as you think you need to, yeah. But we do it every year, but, every 2 years. But if you do it on a regular basis, and especially now, because the legislature's been busy, let's just say that. And many of you are going to be hearing about that, later on. And so it's critical that you know what's in that, and it's not just collecting dust on a shelf.
Thank you.
There was a question over here?
With regards to loyalty, when we're voting, if we're elected officials and it comes down to our vote, does our loyalty lie with the college or the community that voted for us?
It's a great question.
Your loyalty is with the college. Like you are there, and it is interesting part for our community college trustees. They're elected, right? Like you are elected by your community. However, once you take that position, your decisions are made in the best interest of that college. If you're appointed, same thing. You're appointed by a certain person, but you're there to make decisions that are in the best interest of that institution. That's where your loyalty lies. Now, I understand that can get into some conflict issues of like, well, and you're elected and people come at you and be like, we didn't elect you to do X. That's where you need to be prepared to be able to explain why. What I find the best approach is that, well, let me ask this. How many of you, and I'm not trying to call anybody out, but how many of you know your institution or college's vision and mission? You should have that memorized.
Yeah.
Yeah.
Have it memorized because that is your best defense in public, right? I'm not talking about a court of law, but when somebody is like that question of like, we didn't vote you to do that. You can say, this is our college's mission. Decision we made was to advance that mission, and here's how. People generally respond to that. People that are logical and rational will respond to that and respect you for making that. I understand it can be difficult, and you're not going to please everybody 100% of the time. Any elected official will tell you the same thing. So that's your best thing. Know that mission and vision, and try to tie your decisions back to advancing that.
Yeah.
Yeah, I'm going to go ahead. I was just going to say, I have to echo that and echo what you said too, Augie, about consult with your general counsel's office as frequently as you need to, because things change rapidly and you want to try to have the information. Remember when I said rely on those subject matter experts? So rely on those offices that you have available to you, the resources you have available to you to help you make these informed decisions. And yes, learning the mission of your institution, learning its goal is so critical. It's the first thing I ask my regents, the newly appointed regents, to read, because that's going to be what they're using to guide them as they try to make decisions in the best interest of the institution. It's just so critical.
Your question is more profound than it sounds. It really is a very good question, because, I mean, I've actually had conversations with our board member, because, look, to get on a community college board in Texas, you run an election. You go out and you get the vote, and you are voted by folks who believe in you and your vision or whatever you happen to bring as your platform. And, you know, the way elections work is you are beholden to the voters that put you there, in part. And it's not that there's a disconnect, but you have to rise above it. Because when you take that oath and you become a trustee or a regent at a community college, how you got there, it's not that it's irrelevant, because you're always going to want to know what your community is telling you, and you always have to have your ear open to get feedback. I mean, that you don't close that channel down, but who voted for you and who didn't does become irrelevant, because now you've got to do what you need to do in the best interest of the college. And I know it's complicated sometimes, but that's the way it works, and that's the way you get through. So, but it's not an easy question to grapple with. I wanted to say that. I wanted to mention one other thing, just to again put it into real life context. For those of you who've heard me speak before about ethics, one of the things I like to do is I always like to read real headlines from newspapers, because you may be thinking, why am I doing this? You know, why is this, okay, duty of loyalty, yeah, whatever. You know, it's not just a matter of philosophy or, you know, ethics sort of in this higher, lofty sense. If you don't do the things we're pointing out, if you don't know your bylaws, if you don't subscribe to ethical conduct, here are the things that can happen. So these are because one of the things you're charged with is maintaining the institutional reputation of your institution, and you know, and so doing nothing that's going to bring, you know, negative criticism to your institution. So these are real headlines. College trustees should have known ethics rules, experts say. Board passes censure resolution against regent. Trustees' actions can compromise accreditation. Community college placed on probation. Lawsuit claims trustees sought contracts for favored firms. Again, these are headlines from, you know, newspapers. Community college district trustee sentenced to 12 years in a public corruption case. Judge has to remind. Judge has to remind community college that board trustees are representatives of the public. And then community college trustees sought college funding for her nonprofit, records show. What's the end result? All of this played out in public. There was a damage to actually the functionality and credibility of the board, huge diversion of college time, resources, and attention, and ultimately damage to the reputation of the college. And then in really bad cases, people go to jail. So just trying to make it real and put it in a context that goes beyond just, you know, rules.
Well, Augie, I have one more question for you, though. How are our regents, trustees supposed to deal with issues of nepotism?
Again, and this actually happens because, again, so nepotism generally defined is, you know, not hiring somebody that's related to you by 2 degrees of consanguinity or 3 degrees of marriage. You've probably heard those terms before. They're pretty easy to apply. I would still recommend getting legal advice and figuring it out, but you can't hire someone that's related to you at your level. Now, as trustees, before the recent legislative changes, that really meant only your CEO, chancellor, president. That's who you were responsible for hiring. And so it's changed a little bit because there are other positions that you are now, you know, subject to, been granted authority in oversight and in hiring. And so you've got to pay attention to that as well. But I believe it's chapter 523. I may be wrong about the 573 of the education code. You go and check to see what nepotism means, and in who you can hire and who you can't. And of course, the reason for that is important. You can't show favoritism in your position, and you can't go hire somebody that's related to you as a matter of law, not just as a matter of ethics.
As a follow-up on that,
Yep.
Augie, if you're in that position, can't you just resign and then have that person hired?
Well, I think the safe harbor is if somebody's been working there for a period of time before and they're a longtime employee, then you can get elected and you remain on the board. It's when you're on the board and you can't, while you're an active member of the board, bring in somebody that's related to you. Yeah.
I do have, go ahead, Alex.
I understand what you just said, but what about if there's, I mean, conflict of interest, you need to manage them. There are always gonna be a conflict of interest at some level, right? So let's assume that this cousin of mine is one of the best engineers to deal with this, to be the dean of, or the head director of this department. That has to be, I mean, why should I step down if he's qualified?
In regards to nepotism,
Yeah, right, it's the
It-
nepotism.
it's the law. So qualifications of the individual, it doesn't matter. If it's a position where the board is the hiring authority, then it is just a strict prohibition on hiring. It's not something you can abstain from. It is just a clear cut, you can't do it.
But couldn't you at least address that in the conflict of interest disclosure?
So nepotism is separate from conflict of interest. Conflict of interest applies to a contract. Nepotism is in regards to employment.
You can't disclose the conflict and allow it to happen by abstaining from it.
And then there's a whole notion of holdover doctrine as well. Let's say it's like your brother and he is the most qualified. So you say, well, I'm going to step down for the board, and then the board can make its own decision. You technically remain on the board until your position is filled. So that just stepping down is only a part of it. They would actually have to fill the position before any action could be taken without nepotism.
So there are other ethic requirements that you're subject to that include things like the use of resources or gifts, political activity. And Nellie, you want to get into that?
Sure, let's go ahead and touch a little bit on it. But I'm really glad for the discussion that we've been having, because your questions, clearly, you are thinking about these issues, and that's so important, because you will be able to address them now. Because, yes, before you came into this room, maybe you thought you could just simply disclose away an issue of nepotism, but now you know you can't. It is the law. So this is why conferences like this are so important. This is why your knowledge of information is so critical in helping you carry out your duties as a regent or trustee. So let's talk about knowledge of the Texas Ethics Commission. The Texas Ethics Commission has rules about how you should be conducting yourself, what kind of disclosures you should be making. Those are critical. And if you don't know them, I would suggest that you call your GC as soon as you can and make an appointment to talk to him or her and say, let's talk about some of the Texas Ethics Commission rules that govern me in my role as trustee or regent. Those are critical. Also critical are the ethical obligations that your institutions have. Your institutions, I bet, all have entire chapters in your policies devoted to ethical conduct. What constitutes ethical conduct, what doesn't constitute ethical conduct. You have to be aware of those. I know it's tedious, I know it may be a lot, but these are critical pieces of information that's just going to help you in your roles. And these pieces of information, they cover such things as Augie just mentioned, the disclosure of financial statements, the disclosure of conflicts of interest, the rules on what kind of gifts, if anything, you can accept. How do you accept them? When can you accept them? Is there a dollar value on those? These conflicts or these Texas Ethics Commission rules are very important. And your counsel can help you work through them so that you have an understanding of this. And don't think of this as just a one and done, okay? I've reviewed it once, I'm good. No, these issues are going to keep coming throughout your tenure as a trustee or a regent. As you have these questions, as they pop up, and they will, with some level of consistency and frequency, just reach out to those subject matter experts who are supposed to be there to help you do this role. So that's what I would recommend, is my takeaway from what I just said is you learn what the rules are in the Texas Ethics Commission, learn what the rules are in your individual policies, your institution policies on ethics, and then talk to your counsel. So,
So I have a question about
Yes.
that as well. So who's responsible for keeping track of these items that may be given to a trustee? Is it the institution? Is it the individual? Is it the individual that's given the gift?
sure. So, and that's just it. If you are the one given a gift, I would recommend that you immediately, if you're not sure, you have your GC on speed dial. Call them and ask them, I was just given this gift of, in whatever, a vase. And I have no idea what the value of the vase is, but somebody tells me it comes from the Ming Dynasty. I don't know. But pick up the phone and find out. But we, the general counsels, we don't know, right? We have to depend on you to come and tell us. So it's kind of you should definitely have this really good, hopeful relationship with all of the people who are going to hopefully make your life easier, because they're going to be the subject matter experts here, so that you don't hesitate twice to pick up the phone in the middle of the afternoon or the middle of the night and say, this just happened. Can I talk to you about it? So yes, to your question, who keeps track? Well, you're the ones receiving the gifts maybe, so you need to come and reach out to us and ask if you're not sure.
So it may be easier just to refuse the gift.
You could just refuse it if that's what you want. That's always an option. But if you're curious about it, if you don't want to just refuse it, there are options.
And the other side of that coin is making sure that your institution has a process, right? So
Absolutely.
that to manage your expectations. So the issue comes to you, who do I go to? Do I go to the chancellor? Do I go to the
Right.
DC?
Right.
Who do I go to? So having that laid out so you know what to do when it comes up, because it will. That's just reality. It's going to.
It will.
Yeah.
And Matt, you mentioned cost too. Is there a de minimis amount that you don't have to report or consider or worry about?
It depends on what your institution bylaws actually have, because there's the Texas Ethics Commission rules, but your institution bylaws may have a stricter amount, a lower amount. So that's why I'm saying it's so important for you need to pull out the institution ethics as well. Because the Texas Commission on Ethics, they've got theirs, right? And there shouldn't be a conflict between the two, and I'm sure there aren't, but you have some that you want to be sure you're following.
And the Ethics Commission, it sets the floor, right? Your institution can add all kinds of additional ethics requirements on it. And at the end of the day, the ethics are tied to your 3 duties.
Yeah.
To ensure that you can meet those 3 duties without being unduly influenced. So that's why those exist. But the Ethics Commission sets the floor. Your institution may have higher standards to protect the integrity of the institution and yourselves.
And it's I think it's $100 $100 for community college regents and trustees in a 12-month period in the aggregate. So pretty low.
And I'd like to say that, because the reason for all of these rules on Texas Ethics Commission, because we want there to be transparency. There has to be transparency. Transparency is a goal here, right? And to that point, Doug, could you actually speak to us about transparent governance?
Yeah, so you generally have 2 chapters of law that dictate transparency in the acts of the board and individual, and that's Open Meetings Act and the Public Information Act. you're required, if you haven't already, you're gonna have to complete trainings on those through the Texas Attorney General. So I'm not gonna go in depth. They're very vast. The idea behind both is that government action needs to be transparent and public. It does not happen behind closed doors, and members of the public need to know what governing bodies, this is for any governing body that exists in the state of Texas, are transparent and open to the public. So the thing that can get you in the most trouble, and a lot of you on it right now, is that phone in front of you right now. That phone should really only be used for your personal work, not your work as a trustee. Why? Well, because information, if you're dealing with anything that deals with your institution on your phone, that information may be deemed public, and it generally is. So if you're texting with your chancellor or president from your personal cell phone, those texts could be deemed public, right? And if you're doing it on your personal device, not only could they be deemed public under the Public Information Act, you are also the custodian of records for those documents. Generally, everything if you're using the trustee, you all should have like trustee email accounts, and that's managed by the institution. But the institution doesn't manage your Gmail account or your phone text account. And if you have information in there on the institution and somebody makes a Public Information Act request, you're going to get a kind letter usually from the OGC or your public information officer at the institution saying, hey, I need any and all records relating to any conversations you had with the chancellor during this time period. You're responsible for turning that over. You're also responsible for maintaining those records in compliance with the State Archives Commission on record retention policy. So it's also a potential violation if you're deleting text that you're actually required to retain for a certain period. That is a violation. So, and all of that is, I know, it happens. I'm just warning y'all of the ramifications for that. So the best thing to do is have all institution-related activities on an institution device or account, so you're not responsible for maintaining those on your own. If you are, make sure you know the record retention policies for those, and how you're retaining them and what you're doing with them. So that's Public Information Act. Open Meetings Act is very similar, but this is actions by a body, right? Actions by a government body have to be made in public. There are very limited exceptions where you can go into closed session to discuss things. Those are consult with legal counsel, discuss employment issues, certain real estate transactions you go into closed session. But they're very limited. You also can't take any action on those items in closed session. Where you can get in trouble, and once again, going back to your phone, is what's called a walking quorum, which means that a couple of you trustees are texting with each other over something. You add a third, that third person talks to a fourth and then a fifth, and you have what's called a walking quorum. So you have people, a group of a quorum or more board members discussing an item outside of a called meeting. That's a criminal violation. You don't want to end up there. You don't want the media attention. You also don't want to end up in jail. So be very careful with communicating with other board members on topics like this. Now, a good question would be, well, crap, we have a quorum of our board members at this conference, at the Higher Edge Conference, because we all thought it was important. That is an exception from the Open Meetings Act, but you can't use as an opportunity to talk about institutional business. You can go to sessions together, you can learn together, but you shouldn't be talking about institutional issues or items during that training session. Enjoy the time together, get to know each other, go out to dinner, learn about each other's families and lives outside of the institution, but use that time to engage with each other and don't deal with your work as trustee because, well, you're not paid for it. And so, enjoy that time together. So you need to be aware of these things because they do have criminal elements applied to them. But more importantly, it's the idea of you want your action as trustee and the board as a whole to be transparent and open. So when people have questions, They can see the meetings. They can see the records. They can see that you did things the right way, the ethical way, and in compliance with your duties. That's why those laws exist. It's not to punish anybody, but it's to make sure that the people that you represent or that are part of the institution know what actions you're doing and what you're thinking about and what policy choices you're making.
And just one point, I'm sorry, go ahead, Doc.
So I have a question about that as well, sir. You know, I understand the transparency that is necessary for board and board action and all that. Does this relate to subcommittees of the board or ad hoc committees, a standing committee maybe with a smaller number of individuals?
So a couple points on that. One, go back to your bylaws, because these are, once again, these set the floor. Your bylaws may require you to meet posting requirements for ad hoc committees or advisory committees. Follow that. In general, also, well, statute. Some advisory committees are created by statute and they're required to follow the Open Meetings Act. But in general, if your like subcommittee, advisory committee is one, less than a quorum of board members, and two, is making decisions that are then rubber stamped by the board, then you're not required to comply fully with the Open Meetings Act. But if your advisory committee is, making decisions and the whole board just rubber stamps those, there is an argument that is actually board action and you need to follow the Open Meetings Act. So once again, talk to your general counsel about the specific situation and issue to get the best advice.
I mean, and that's a great question, because that comes up, that'll come up in how each of you decide to organize yourselves. Do we want to have subcommittees and then have them come up to the board? Or is that being redundant? Do you just want to have committees as a whole? I mean, so it's a good question. I just wanted to also point out or highlight the importance of the agenda, okay, under the Open Meetings Act. Mm-hmm. Your agenda must be clear enough to let the public know what you're going to be talking about. And does that mean you have to have a detailed outline, subpart, Roman 1, subpart A, B, C, no. But it's got to be clear. How about Regent's comments? Is that clear enough? No, that's not going to be clear enough. If it's a matter of action in particular, if you've got an action item that's going to come up, you want to make sure, and I know this is for your CEO, chancellor, president, or other administrators to take care of, but at the end of the day, it's the board and the college that get sued over a violation of the Open Meetings Act because your agenda wasn't clear enough. So, another practice point.
And just as a follow-up too, and this doesn't apply just to your the open meeting part of your meeting, it applies to your executive session. In executive session, don't forget, sure, you can have really frank discussions, but only frank discussions about items that you have posted about. So if you're going to talk about a real estate matter and you're going to be negotiating terms, okay, have those frank discussions in executive session, but don't because you've posted it clearly, but don't let that discussion morph into something else, a personnel issue, because that was not on your agenda. And it is a violation to have that type of discussion that isn't properly posted. So even for executive sessions, you've got to be careful. Yes, sir.
Just have one question. If we can back up just a little bit, I was thinking in terms of the best practice on, say if you had a software company that the college is doing business with, and you just happen to be out of town at a convention, and that company decides to buy dinner for everybody there, is that considered a gift over the $100 limit, or how would you consider that?
If they have made a purchase of over $100 of what now? I'm sorry, I missed that part. Of just food?
Food. If you take a bunch
They
of
take the board out to dinner.
it's gonna go over.
They're taking the board out for dinner, and they're there at the dinner? Yeah. Are you uncomfortable? Would that make you feel uncomfortable? I don't mean to turn it around, but I'm just wondering.
That's why I'm asking the question.
Right.
Yeah.
Yeah. Quite frankly, information there about, okay, they're buying us food, they're going to be there, and this is a company that actually, this is a owner or something of a company who's going to have a matter brought before the board. Is that also part of it?
We're already doing business with.
You're already doing business with them. You know, some would say that it appears to be maybe, there's an appearance of impropriety, but is that improper? You're having the meal there. Quite frankly, I'm not exactly sure that would rise to the level of a violation. How do you all agree, or do you all disagree with that? Because there are issues here, right? If you called me, I would say, you know what, I'd suggest that you not do that. I would recommend against it, right? But somebody might have a different take on it.
I think it's very clear if you're like going out for bid and they happen to be interested in bidding, then that is that's not okay.
Right. But if you're already doing business with them,
And there are exceptions. So, for example, like you have if you have outside legal counsel, they can, or outside architects, they can actually take you out for dinner as a client without implicating ethics issues. But in general, if it's because once again, those are professional services that don't go to the lowest bidder. But generally, if you're talking about a contract that went out for bid and it's a current contract, it does raise potential ethical issues.
but if the contract has already been consummated, the relationship is already ongoing, right?
Yeah.
And that was, I thought, your scenario, that it's already ongoing, the bid was already awarded. Can you take them out or can they take you out for some kind of a meal? The appearance of impropriety is there. If you called me, I would probably recommend against it, but I err on the side of being more conservative there. Somebody else might not be.
Those would be the kind of things that you would definitely want to visit with your counsel about, so that you can give them all the details and they can look at the situation and give you specific legal advice. The discomfort that you might see from us up here is that Doug forgot to give you the disclaimer at the beginning. None of this is to be taken as legal advice or counsel. Seek the advice of your own professional legal counsel. But these are difficult issues. The threshold, there's an exception, for example, to the gift disclosure requirement, and that is if it's someone who's truly a friend, a longtime friend that you knew, and you feel very comfortable accepting something from them as a holiday gift or as a birthday or celebratory gift. But other than that, it's like what Nellie says. How is it going to look like in the press? That's why I read the headlines. How is it going to look if it comes out in your local media? Entire board of trustees taken out at fancy dinner at, Del Frisco Steakhouse last night. And how is that going to look? Because that's the institutional risk, apart from the legal risk that you've got to also have in your calculus.
Larry, I wouldn't worry too much about McDonald's, though.
Okay.
And I would say one other thing. From this presentation, I want to point out one item that I started out by telling you all about the fact that none of you have authority or power as individual board members, right? As individual Board of Regent trustee, or you don't have individual power. But I'll tell you what you do have. The fact that you are a regent, that you are a trustee, that in itself has some level of power. And let me give you an example. Many, many years ago, there was a commercial involving a investment banker, an investment firm. The investment firm was called E.F. Hutton. And the commercial said, when E.F. Hutton talks, people listen. Well, when a regent or a trustee speaks, people listen. So you have that level of power. It is very important that you recognize it and that you be careful about how you use it and how others may perceive you as using it.
Thank you, Nellie. So Augie, we've covered a lot of topics here, from ethics, conflict of interest to the roles and board governance. Bringing us back, how do all these play into the board's primary role, which is policy development? And how should board members view that role in light of all the information we've talked about today?
So we'll begin with the basics, and it's been talked about before. Knowing your vision, your institutional vision and mission, and making sure that the bylaws, code of ethics that you construct, align with that. Making sure that every policy that you're asked to pass or promulgate is in accordance and in alignment with that. These are all just mechanisms for how you get there. No, I mean, it starts with an overview of the law, and we've covered some of that. That's where it begins with. And then that gets into regulation, which ultimately helps you figure out what kind of policies you want to promote that lead to the processes and procedures that go on your campus. It's sort of connected in that way. It begins with the big picture law, goes through, policy, and ultimately your processes, which is how your college functions. So having knowledge of all of this, being aware of what you need to consider before you get into policy formulation is all important. The other thing that you have to be mindful of, and is for another session, not us, we're just the lawyers, but the role that budgeting plays in all of this. You can be as aspirational, pie in the sky, blue sky as you want. You're going to do all these things, but ultimately, you are not limited, but measured, right? You're measured by the financial resources that you have. As I said, not all 50 community colleges in Texas are the same or built the same. That's the beauty of it. I love the fact that we have colleges everywhere. But it means that some of us are built differently and able to do things that others aren't, but vice versa. So I mean, I think everybody, but knowing what you have, being good stewards doesn't mean just passing a budget that's responsible, but it means being involved from the beginning and engaging in that budget process and knowing what the details are and where the monies are coming in from and what you can, ultimately you have to pass a budget. That's one of the other duties. And I frankly characterize that as an ethical one, right? It's one that Nellie mentioned earlier, your duty of loyalty, of duty of care requires you to know what's going into it. Doesn't mean you have to be a budget expert, but you certainly have to know what kinds of resources you're going to have before you start, getting in the process of coming up with new programming that requires policies. And so that's how it all fits together. I know it sounds easy. I know it's not. I know it's complicated, but I'm encouraged that all of you are going to do the right thing. So.
And I'll just add two things to that. I've done a lot of board trainings, and I always bring this up of usually some of the lowest attended board meetings are the board workshops and when you approve the board. However, in my mind, that is the most important action a board takes because that sets your priorities. That is it. And if that's not tied to your mission and vision, then you're going to be out of whack for that entire cycle because nobody's operating from the same page. The budget is your guide. The other thing is, I know we brought up a lot mission and vision and just you need to know it. Well, you also need to know that you're responsible for that mission and vision. We talked about reviewing bylaws. Also, when you do those team building exercises, when was the last time we looked at our mission vision? Is it time to bring a group together to kind of look at, do we need to change it? Does it need updating? Are we all on board with this? So you don't have to be well, I'm on the board now and I have to follow this. You can have questions about it. You can bring it up of hey, is this something we want to bring up for further discussion on potential revisions to that? Because it matters.
And maybe this is a closing step. I know we're coming
We got a
close
couple
on
minutes,
time.
yeah.
Yeah. But so you may ask yourselves, well, okay, Augie, in addition to staying legally compliant, what's the importance of ethical conduct amongst the board or my own ethical conduct on the board? Well, because believe it or not, for those of you that are new trustees or regents, your chancellor CEO is watching you. Your administrators are watching you. Your faculty are watching you. Your students are watching you. Your community is watching you in the end. And the way you conduct yourselves in a meeting, and it's probably for another time and a topic, although part of this is going to be you watching the video recording of the recent hearing, House Senate subcommittee hearing on expressive activities on campus, where civil discourse was discussed a lot. And we've talked about free speech and other panels and all that before. We won't get into that, but the discourse that you have amongst each other and with each other, the way you talk to your staff, the way you talk to your CEO and chancellor, believe it or not, is a big deal. The way you address administrators when they come up to the podium to give you, an update on this program or that, that's a big deal. How you conduct yourself, how you treat your people is, I can't stress that enough. It's paramount in how you do your job. And ultimately, I've seen this, I think, in my own community. If you can rise above it, then maybe other governing bodies in your local community will follow suit. And if not, then you can see the difference. You can see the contrast. So that would be my final tip off to you as a practice point. When you go prepared, be civil. That doesn't mean to be easy. Ask the tough questions. That's why you're there. But in the end, be civil about it, and it'll all work out. And when in doubt, reach out to your general counsel. We're here to help.
Nellie, do you have any final remarks?
Any final remarks would be this. Even if you don't know the resources you have available to you, after this session, just sit down and find out who your GC is, who your CFO is, who your chief academic affairs person is, who your auditor is. Put their numbers into your phone, put them on speed dial, because you're going to be needing them. And if you aren't calling them with some degree of regularity, then you want to rethink maybe your role here, because they're there to help you. Let them help you. So reach out to them. They may be reluctant to reach out to you since they don't know you yet, but they want to know you.
My final comments are just appreciation. I appreciate your service and commitment to higher education in the state. Education, I believe, is the most fundamentally important thing we do as a government. And I sincerely appreciate you serving on these boards and working in the best interest, for our state, for our students. We only get better through your service. Second is, I hope you take the opportunity during this session today, and if you're at the conference on Tuesday is Wednesday, meet other people from other institutions, learn from them. They all have great best practices that, one of the best things I come from these conferences, not just the panels, but meeting other people and be like, oh, they do it this way. We've never thought of that. So take the time to network, get to know people, how boards operate in different ways, and share your own experiences. That's the only way we get better is collectively. Those are my concluding remarks. I know we have a couple questions a couple minutes if anybody has any questions.
I have a question.
Yeah.
You mentioned that have your general counsel, your CEO, are some of the administrative numbers on speed dial. Now, should we approach our CEO, our president first, or without consulting?
If that is your
him or her?
process, for sure, absolutely.
Okay.
Yes.
Without, first, before calling our general counsel.
That's how we do it.
I would recommend it because it really helps people
Right.
all have the same information. Everybody knows which way you're moving, how you're moving.
So we don't directly call the general counsel.
It depends on your
you-
institution's bylaws.
But you also, in your case, if your bylaws say you go through a specific person, so be it. But there's nothing wrong if you have informed your chairman, maybe, I'm going to call the GC because I have a question about an item that's come up. call the GC. That's what they're there for. They're there to provide information.
Someone, yes, ma'am.
So I have been recently appointed to head the bylaws committee. And I'm using this as a.
Congratulations.
I'm actually excited about it. But I was wondering, since there's so much talk about bylaws, I've looked over our bylaws. I think they look pretty good. You know, they're reflecting all of these concepts and duties and everything. But I thought for folks who had seen probably more bylaws than they care to remember, would anyone have a little bit of a deep cut, great bylaw or area to consider incorporating into the bylaws because I'm about to amend them?
Happy to send you mine.
Okay.
Yeah, just give me your email. I'm happy to, yeah. I can share those.
I can say generally, what I find most important is you can draft the greatest bylaws anybody's ever seen. It only matters if people know them and can follow them, right? They have to be
That's it.
practically usable, and if they're not, then they're not worth it, and they could actually get you in trouble. So make sure that you have the buy-in from the entire board and they understand the process and it works for them, like it logically works.
Having the buy-in is so important.
Yeah.
Because without it, you're right. Bylaws could be the best written piece of poetry ever, but nobody read it. So,
Can I just add something to that? I've been working on our bylaws, and a great resource was our CAT organization.
Oh, yeah.
Yes, look at it, yes, I'm not the only one that's saying this. And also ACCT is a great resource for putting together your bylaws and your governance policy.
So for you community college trustees, so CAT
Yes.
actually puts out a
There
handbook.
you go,
So it'd be something that you all can look at. It's a great resource. And
great resource.
shout out to Nicole. Thank you, Nicole. Nicole Evers. Yeah. And, okay. I think we got stopped in the back.
We did. Thank you all for your time.
thank you.
Thank you all.